Best practices that investigators should follow to prevent false confessions. My name is Joseph Buckley, president of John Reid and Associates. In this presentation, we will discuss three primary topics. Number one, the most frequent causes of false confessions. Secondly, the procedures that investigators should follow to minimize, if not eliminate, the possibility of a false confession. And the questions that should be asked in a confession case to determine the validity of the confession. The purpose of an interrogation is to learn the truth, and there can be several successful outcomes of an interrogation. Number one, the subject admits their guilt for the crime they committed in a corroborated confession. Number two, the suspect may reveal that, in fact, he did not commit the crime, but he knew and had been concealing who did commit the crime. And thirdly, the suspect may reveal that he didn't commit the crime, but was lying about some important element of the investigation, such as his alibi, because he didn't want people to know where he really was or what he was really doing at the time. And a fourth outcome is the investigator feels that the subject is probably telling the truth and probably not involved in the commission of the act. Over 60 years ago, in the first edition of their book, Criminal Interrogation and Confessions, John Reid and Fred Imbaugh expressed concern about the possibility of a false confession from individuals, particularly who had a mental illness, and suggested that there were two ways to verify the accuracy and veracity of incriminating statements. Number one, see if the subject can tell you details of the crime that have been concealed from the public. For example, nobody knew the victim was stabbed to death. Nobody knew what was stolen during the burglary. Nobody knew what room the fire was started in, and yet the subject is giving you that information. Secondly, you might refer to some fictitious aspect of the crime and test whether or not the subject accepts that fictitious element as actual facts relating to the occurrence. Since 60 years ago, when John Reid and Fred Imbaugh wrote their book, clearly there have been thousands of court decisions examining the admissibility of confessions. We'll outline the common characteristics of the majority of false confessions, which in almost all instances involve inappropriate conduct by the investigator. The knowledge that potentially false confessions may occur as a result of coercive behavior, such as threats of harm and promises of leniency, has been known to investigators for many, many decades, but undoubtedly the awareness was heightened with the development of DNA exonerations. According to the Innocence Project website, to date there have been 253 Innocence Project exonerations, 29% of which involved false confessions. And in almost half of these cases, the subjects were under 18 years old or mentally impaired at the time of their arrest. According to the National Registry of Exonerations, of the exonerees with reported mental illness or intellectual disabilities, 72% had confessed. 40% of the exonerees who were under 18 years old at the time of the crime falsely confessed. So it should be noted by all investigators that individuals who are mentally impaired and juveniles should be considered more susceptible to false confessions than the population at large, and so we should all exercise extreme caution in those interrogations. While the overwhelming number of confessions are in fact true and accurate, certainly false confessions can occur. With very few exceptions, false confessions are caused by the interrogator engaging in coercive or inappropriate behavior, as illustrated in a careful examination of the first 250 DNA exoneration cases. After reviewing those 250 exonerations, Davis and Leo pointed out that, quote, many and perhaps most of the interrogations in the DNA exoneration cases crossed the line of proper interrogation techniques through the use of explicit threats and promises, feeding suspects crime facts, and or other coercive practices. This assessment was subsequently confirmed by J.P. Blair, who reviewed over 100 false confession cases and reported that, quote, this study failed to find a single false confession of a cognitively normal individual that did not also include the use of coercive tactics by the interrogator, such as the use of physical force, denial of food, sleep, or the bathroom, explicit threats of punishment, explicit promises of leniency, and extremely lengthy interrogations. So, in looking at the history of false confession cases, the following are the primary causes and contributing factors that lead to false confessions: physical abuse and the threat of physical harm. The courts have long recognized that physically abusing the suspect or threatening them with physical harm can cause an innocent person to confess. Threats of inevitable consequences. An example of an inevitable consequence would be telling a suspect that if he didn't confess, his children will be taken away from him. Or telling a suspect, if you don't cooperate with us and tell us that you did this, I'm going to make sure you never see your wife or kids again. Promises of leniency. The courts have consistently found that advising a suspect of the potential penalties he may face based on the type of crime that he committed is not coercive, but promising the suspect a benefit of confessing, such as receiving a shorter sentence, getting counseling instead of going to jail, or being able to go home and not getting arrested, can nullify a confession. Denial of rights. In reviewing false confession cases, in a number of instances, the subject was denied their rights. They were in custody, had been advised of their rights, but during the course of the interrogation asked for an attorney, and that request was ignored, or said that they didn't want to talk anymore, but the interrogation continued anyway. In some juvenile interrogations, they were denied the opportunity to see a parent or guardian in violation of the state law. Denial of physical needs. In a number of false confession cases that lasted an excessively long period of time, in some cases 16 hours or more, the subject never had a chance or an opportunity to get something to eat or drink or sleep or even use the washroom. Excessively long interrogations. In many false confession cases, the interrogation process lasted an excessively long period of time. One study of 44 false confession cases noted that the average length of the interrogation was 16.3 hours. Several individuals who gave false confessions subsequently stated that they confessed just to end it, to end the process, and just to be able to get out of there. They felt confident that the subsequent investigation would prove that they had nothing to do with the crime. Disclosure of crime details. Many false confession cases include details about the crime that in theory only the guilty person could have known, such as what the murder weapon was, what room the body was found in, where the fire was started, what was stolen in the robbery, etc. However, in some of these cases, a careful analysis of those cases found that these details were revealed to the subject by the investigators, oftentimes inadvertently, during the questioning, or were revealed in photographs that the investigators showed the subject. The disclosure of crime details to the subject contaminates the confession in that it is difficult, if not impossible, to determine if the subject had independent knowledge of this information and these details, or if he was just repeating what he was told. Failure to properly take into account the subject's mental limitation and/or psychological disability. In a number of false confession cases, the subjects had severe mental limitations, a very low IQ, and in several cases were found to be extremely psychologically susceptible to suggestions of their guilt. The key factor in those kinds of circumstances, where there's a concern about the subject's mental or psychological capacity, is to establish in the confession that they had independent corroborating knowledge of details of the crime, such as the location of the murder weapon, the bloody clothes, the stolen jewelry, etc. Failure to properly modify approaches with socially immature juveniles. Socially immature juveniles, as well as very young subjects, can be more susceptible to suggestion/active persuasion and are motivated to please persons of authority, so caution has to be exercised in the questioning of these individuals. Again, independent corroborating information will be key in assessing the validity of their statement. Failure to properly corroborate confession details. A review of false confession cases will show that a number of these confessions contain details that were significantly different than the actual crime itself. such as the subject stating he stabbed the victim when the victim was actually shot. The best form of corroboration is for the subject to reveal accurate information about the crime details that were not disclosed in the media or by investigators to subjects during the interview process. So to summarize, the primary contributing factors to the cause of false confessions are physical abuse of the subject, threatening physical harm, threatening inevitable consequences, promises of leniency, denial of rights, denial of physical needs, excessively long interrogations, disclosure of crime details to the subject, failure to properly take into account the subject's mental limitations and or psychological disabilities, failure to properly modify approaches with socially immature individuals, and failure to properly corroborate confession details. The best way to avoid false confessions is to conduct interrogations in accordance with the guidelines established by the courts and to adhere to the following core principles and best practices of the Reid technique. Do not make any promises of leniency. Do not threaten the subject with any physical harm or inevitable consequences if they don't confess. Do not deny the subject any of their rights. Do not deny the subject the opportunity to satisfy their physical needs. Withhold information about the details of the crime from the subject so that if the subject confesses, their disclosure of that information can be used to confirm the authenticity of their statement. Exercise special cautions when questioning juveniles or individuals with mental or psychological impairments. Always treat the subject with dignity and respect. Always conduct an interview before an interrogation. Absent a life-saving circumstance, the investigator should conduct a non-accusatory, non-confrontational interview before engaging in any interrogation. Conduct an interrogation only when there is reasonable belief that the suspect committed the issue under investigation or is withholding relevant information. Certainly, we want to attempt to verify a subject's alibi before moving from the interview into an interrogation. And when we're interrogating a non-custodial suspect, somebody who's not under arrest, we do not want to deprive them of the ability to leave the room. We don't want to block their access to the door. We don't want to conduct excessively long interrogations. It's our view that if after 3 or 4 hours the subject is adamant in their denials, the situation should be reevaluated. When a suspect claims to have little or no memory for the time period when the crime was committed, the investigator should not lie to the subject concerning incriminating evidence. And we always recommend that interviews and interrogations be recorded. We caution investigators that the confession is not the end of the investigation. Following the confession, the investigator should investigate the confession details in an effort to establish the authenticity of the subject's statement, as well as attempt to establish his behaviors before and after the commission of the crime. A couple of interesting comments from the court about the Reid technique. In U.S. v. Jocks, the court said, quote, in his declaration at the hearing, Professor Hirsch, he was the expert witness on false confessions in this case, Professor Hirsch explained that the primary cause of coerced compliant confessions are certain interrogation methods employed by law enforcement, including a widely used method known as the Reid technique. Beyond his own intuition, however, Professor Hirsch offered no basis for concluding that these tactics had any tendency necessarily to cause false rather than true confessions. Professor Hirsch's declaration offered no other evidence of the danger of certain police interrogation tactics, and the Reid technique in particular, except to say that, quote, the use of these tactics employed in the Reid technique and their correlation with false confessions are extensively documented in the literature. Despite his broad statement, he did not provide any further explanation. So the court concluded, in sum, the proffered expert testimony to the effect that the Reid technique enhanced the risk of an unreliable confession lacked any objective basis for support whatsoever. Although Professor Hurst insisted there was a wealth of information about the risks of the Reid technique, he could point to none. False confession experts often say the Reid technique is coercive, and there are many cases to establish that. But when you look at those cases, what you find is that the investigators did some of the things we've already detailed as causes of false confessions, and that we recommend, of course, not to do. In another case, State versus Belunde, the Superior Court of New Jersey stated in their opinion, quote, no case supports the contention that using the Reid technique renders an adult's confession inadmissible. A suspect will have a natural reluctance to admit to the commission of a crime and furnish details. Therefore, an interrogating officer may dissipate this reluctance and persuade the subject to talk, as long as the will of the subject is not overborne. For a complete list of questions to ask to determine the validity and voluntariness of a confession, we have an investigator tip that is entitled, What Questions Should Be Asked to Determine the Voluntariness and Validity of a Subject's Confession? You see the link on it on the screen. If you go to Reid.com, that's our website, Reid.com, and there's a tab on the homepage called Resources, and you click on that, you see a drop-down menu, and that refers to investigator tips. Click on that, and you can search for what questions should be asked, etc., and that will come up for you. Thank you very much for taking a few minutes to listen to this presentation.